Hi, my name's Alex Dolphin and welcome back to another episode of Ex Ante. Today we're going to discuss the case Taniguchi versus Can Pacific. This case was heard in the Supreme Court of the United States in the year 2012. Let's go ahead and jump into the facts of the case. So a professional baseball player slipped, fell, and hurt himself. This professional baseball player was from Japan. He sued the resort where he slipped and fell. Now in this lawsuit there was a lot of translation going on because the plaintiff was Japanese and they were translating documents and arguments back and forth from English to Japanese. Now, Congress had passed the Court Interpreters Act. What the Court Interpreters Act did was it allowed prevailing parties to recover costs for interpreters. Now, the question before the court is, does the Court Interpreters Act cover written translation? Or does it just cover oral translation in a courtroom? So the court has to decide, does the word interpreter mean just oral translation, oral on-the-spot translation, or does it also mean written translation from one language to another, outside of the courtroom? So that's the question before the court. And Justice Alito delivers the opinion for the court. And what he says is the word interpreter, in its ordinary meaning, only means live oral interpretation. It does not mean written translation from one book to another, from one language to another. That written translation is not covered by the Court Interpreters Act because the ordinary meaning of an interpreter is only an oral translator. To evidence the ordinary meaning that Justice Alito has gotten to, he uses a lot of dictionaries and he cites to a lot of dictionaries saying that, hey, look, this is the ordinary meaning. And this was the ordinary meaning of interpreter at the time Congress passed this statute. That was the ordinary meaning of interpreter at the time Congress passed the statute, and we need to just give the word its ordinary meaning. Now, there might be an acceptable usage for interpreter to cover written translation. I mean, he does concede that there's one dictionary, Webster's Third, that does cover this, but he doesn't find that completely persuasive. He says that we should just look to the ordinary meaning, not what an acceptable usage of the word might be. Now, Justice Ginsburg in the dissent says this is an acceptable usage and we should accept the acceptable usage of the word. That should be covered by the statute. Justice Ginsburg turns to the purpose of the Court Interpreters Act, and she says the purpose of this act was to provide translation for parties that don't speak English back and forth if they prevail in a lawsuit. So she makes an argument about the purpose of the statute and says because the purpose of Congress was to provide for this translation, we should also give the word interpreter the meaning that it should cover written translation as well as oral translation. So the holding of the court and the majority is that the word interpreter only applies to oral interpretation because that is the ordinary meaning of the word. Just to illustrate this example a little bit more, let's consider the word tomato. Tomato is ordinarily used to refer to a vegetable. Most of us think of tomatoes as vegetables. But if you know a little bit more about tomatoes, you know that they're actually classified as a fruit of the vine. Tomatoes are actually fruits. So let's say today Congress passed an act that said there is a special tax on vegetables. There's a special tax on vegetables if they are imported into this country. So because the ordinary meaning of a tomato infers it's a vegetable today, what about 50 years from now? What if 50 years from now all the schools teach the kids that tomatoes are fruits, they're not vegetables. And so the ordinary meaning of a tomato now, it refers to a fruit, not a vegetable. And most of society just considers tomatoes to be fruits, not vegetables. Now there's a question, should we consider the ordinary meaning of the word at the time the statute was enacted, or the ordinary meaning of the word at the current time when the statute is being enforced or when there's a litigation over the statute? So the purpose of, saying we should hold to the ordinary meaning at the time the statute was enacted is to give respect to legislative intent. The legislature crafted this statute. It put a special tax on tomatoes as vegetables. It clearly meant to cover tomatoes. That's a substantial portion of the vegetables that we eat as a society. So we should respect that legislative intent. Now, the argument that we should look at the ordinary meaning of the word in the year 2050, for example, when society believes that it's completely a fruit, is, well, if this statute only is meant to cover vegetables in the abstract, in the broad abstract, should we really apply that to something that society now considers a fruit? Does that put the person on notice, the importer of tomatoes? Are they really put on notice by the law that they have to pay this extra tax on tomatoes because, Congress thought they were vegetables 50 years ago? And so I think that's an interesting debate. On one hand, you have respecting the legislative intent at the time the statute was enacted. And then on the other hand, you have putting the population on notice of what the law is. And to do that, the statute the society has to give meaning to an ordinary meaning to the words as they're used in society. So you could see how that could lead to some counterintuitive results. But thanks so much for watching. I hope you enjoyed this video. If you'd like to see more, go ahead and hit that subscribe button. And I hope you have a nice rest of your day. Bye-bye.